meeting. Thank you very much for your patience, Suze, while we just reorder ourselves. I have some of the questions that we've put to the other guests. We're going to put some of those to you. So I'm going to ask my colleague, Assembly Member Small Edwards, to pick up his question to you.
Good afternoon, Suze. I just want to ask, what are the unique challenges that social tenants face in relation to service charges?
I think that's a simple one to answer. I don't think there is anything that makes social tenants unique in that sense. So just to be clear, that although we started out as a social housing action campaign, we do have a number of our members now are from the PRS and are from councils as well as housing associations. We started off mainly focused on housing associations. And it's clear that there is a commonality of issues when it comes to service charges. So it doesn't matter if you are on quite what would be considered a reasonable wage, if your service charges are becoming unaffordable, the issue is the same for you. I guess where there is a distinction is between shared owners and leaseholders, as opposed to full renters. What you aren't going to get as a tenant, as a full tenant, you aren't forfeiting any property that you felt that you owned previously. So that would be the distinction. But otherwise, there is a commonality of the issues. The issues are the same. Access to justice is a huge problem. So when you know that your service charges are wrong, actually getting access to justice is hugely problematic. There is a massive enforcement gap. So even when the landlord acknowledges that your charges are wrong, actually getting any kind of enforcement of a refund is very difficult. And obviously, the sanctions that either the tribunal or the housing ombudsman can apply, and it's mainly the tribunal system, because the housing ombudsman can't deal with the content of the service charges. They can only deal with how well any complaint was handled. But even then, the fines are laughably small, compared to the incomes that these landlords have. So I don't think there is anything that is unique in that sense.
Thank you. Thank you, Chair. Yeah, sure. My next question was, how common do you think unreasonable service charge costs are?
Well, I mean, we have people who are self-reporting. So in a way, we are seeing people when they've got a problem. But what I can say is that people will present to SHAC with a wide range of problems, but overwhelmingly, the highest category is about either inaccurate or extortionate or service charges. So either the service charges are getting too high or that they are inaccurate is the biggest single issue. Probably unfair rents, the rents levels is kind of second to that, but absolutely highest, top of the list is the unfair service charges. So we think it is very common. Certainly out of the vast majority, 95% maybe, of the service charge accounts where people have sent us details and we've been able to look into them, they are riddled with inaccuracy. I mean, this isn't just somebody hasn't really put in enough, one landlord or two landlords haven't put enough checks and balances in the system. This is a system that is being played by landlords. So the service charge accounts are absolutely riddled with inaccuracies.
Do you have any data on how much service charges have increased? And obviously you mentioned it a bit there, but in terms of the main drivers of the rise, do you think it's all purely just gaming the system?
We've done two reports. So the first report was really looking at the different forms that what we would call service charge abuse takes, and that is done in case studies, although there is some data in there which kind of quantifies as well. And we did a second report, which is a quantitative report, which is really on the impact on people, so affordability. So on there, we've seen the kind of hundreds, we've plotted that some people have had hundreds, only a small percentage of tenants and residents, but for some people it's been hundreds of percentage points that their service charges have increased. The highest that we got reported in that was around 2,500, but that was in 2021, so they've gone up considerably since then. SHAC doesn't really have the resources to do kind of wide-scale academic standard of research. I think you would need a proper research body to do that. But you could get that information from landlords. I mean, landlords are getting, enough money from the public purse that certainly government could ask for that information in return. They could identify how high they are. That information is there. It's all collected by the landlords anyway.
Thank you very much. Back to you, Chair.
Thank you, Suze. Assembly Member Lord Bailey.
Hi, Suze. Social tenant. Oh, excuse me. Thank you. Sorry. How successful are social tenants in challenging unreasonable service charge costs?
Yeah. Again, I'm going to speak for all of us, not just social tenants, but it is very, very difficult for them. The only place that you can really go to, the only authority that you can go to, so I'll talk about the kind of establishment mechanisms, if you like, then I'll come on to the mechanisms that they've got that aren't establishment ones. But the only establishment one that you've got is the first tier tribunal. And the first thing you've got to do if you want to go to tribunal is to try and get the information about what your service charges are, what the components of it are. Leaseholders and shared owners have at least a theoretical entitlement to the full statement and the invoice pack. So that's Section 21 and Section 22 of the Landlord and Tenant Act. But that doesn't apply to full renters. They don't even have the right to see what they are paying for, other than, they don't have a legal right. Obviously, the landlord might tell them anyway. So your first battle might be, especially if you are a renter, your first battle is actually to get the information. And they've sent me this massive bill. What does it all relate to? What are the invoices? And then you find your double and triplicate invoices in there. You find invoices for services that aren't provided to you. You find completely extortionate and inexplicable rises in charges. You find the things that previously were provided just as part of your rent, if you're a shared owner or a full renter, and just part of the compliance if you were a leaseholder before. It's a bit like the move from BA, for example, into a low-budget airline, where you suddenly have to start paying for absolutely everything, including things like fire safety compliance, water hygiene compliance, that kind of thing, which has always been provided, but all of a sudden they started charging you for it. So the list of items is growing. If you can get the information, you then have to go to court. Obviously, legal aid doesn't cover a lot of housing issues, and certainly I don't think covers any service charge, challenge. So you are going to go into court on your own, or if you can source free legal advice, then you might get free legal advice. But obviously, that it's hen's teeth, really, free legal advice on something like this. No win but no fee lawyers won't take it on, because you can't ask for legal costs from the other side. Therefore, they generally can't make money out of service charge cases, and they won't take them on, which is why they're almost exclusively interested in disrepairs cases, the no win for no fee lawyers. What also happens is that the landlord will write to them the day before and tell them, or the day, just coming up to the court case, and tell them that what they're going to do is to ask the court, if they lose, if the tenant or resident loses, to cover their legal cost. And obviously, because they are turning up with a room full of barristers, a room full of solicitors, full-time paid legal staff from within their own department, those costs are going to be absolutely considerably higher than they are for the tenant or resident who's sitting alone on the other side of the court. So that's very intimidating. It's actually very, very rare. We haven't heard of a case of where, even when tenant or resident has lost, that a judge has granted it, but we know of lots of cases where they've made that threat. And people have to take that into account. They can't just say, oh, it's very unlikely, therefore I'm not going to worry about it. They do worry about it, of course they do. Because that could be hundreds of thousands of pounds. Sorry.
I know you're not a legal expert, and neither am I, so you might not be able to answer this question. But in most of the British legal system, if you win, you can go for your costs. How come it's different in this arena? What's the difference? Is this just historical, or is there a technical reason you know of?
That is way beyond.
Okay. I'm just chancing my arm because it feels so different to the rest of our legal system. Yeah. Is another thing I'll be tabling a question about in the Lords.
Yeah. I think it's very different, actually, just on that. It's very different to our legal system, but it's also very different to every other area of retail, isn't it? Because if I go into a cafeteria and order a cup of coffee and they try and charge me for a cup of coffee and 3 pizzas, I'm within my legal entitlement to walk out only having paid for that cup of coffee. But somehow this is reversed when it comes to items that are not just a few pounds, but a few £1,000s. I don't even have the same legal protection for those. So it is very, very different in the case of the landlord relationship over service charges.
Okay, thank you very much. Appreciate it.
Thank you. Assembly Member Garbutt, please.
Hello, Susan. Thanks for your answers so far. My question is specifically about the case of estate regeneration and the impact that has on specifically the service charge for social tenants. I understand that there are experiences of it increasing, and I don't know if you could speak to that at all from cases that you're aware of.
For regeneration?
Yeah, from estate regeneration, yeah.
And its relationship to service charges?
Yeah, service charge increases after estate regeneration.
Okay, well, I don't have any particular data on that. I mean, that's not an issue that's really being presented to us. I mean, we've had cases where people have tried to fight regeneration, but that usually results in people being in social cleansing and people being moved away. So we don't have a lot of data on what happens with service charges afterwards.
Okay, well, that's an answer in itself. Thank you.
Thank you very much, Suze. I do have one question which we put to the other panellists, and you really helpfully outlined that SHAC it extends beyond social tenants to include a whole range of other tenures and people that live in social housing, whether they're tenants or not. But I just wondered what happens in the case of somebody that SHAC would work with who can no longer afford their service charge. What support is available?
This was something. Thank you for that question. I mean, this was something that that I was going to outline actually, because there's an obviously an access to justice. There's a gap there, but there's also in terms of enforcement, in terms of the way that the courts order it, and we do end up with can order a refund, but they can't actually force the landlord to do it, and there's no agency apparently that can force these landlords to do anything, even if they're housing associations and getting millions of pounds from government. What we will do, where people can't afford it or aren't willing to pay because they know the charge is wrong, what we will do is we will support people to withhold the payment as safely as possible. In fact, evictions in the housing association sector are massively high. They do happen, but they're not massively high. What ends up happening is that people get into deeper and deeper arrears, and there's very good, easily accessible data on the levels of arrears within housing associations. So it does build up a whole load of arrears for that person. That obviously is a huge stress, it's a huge financial burden for them as well to be trying to pay off these arrears, but we will support them to withhold payment as safely as possible. And, in terms of kind of not going through the legal mechanism, that is the other option that is open to people. We believe that these kind of rent and service charge strikes are on the card in a mass scale. We haven't seen it in a mass scale in Britain, and we haven't seen rent strikes for a long time in Britain. But I get the sense that this is coming down the road. People are getting to the end of their tether, and in the end, when it comes to a choice between do I feed my children or do I pay my service charge, our advice to the member would be feed your children. The landlords, especially housing association landlords and private landlords, housing associations are sitting on £4.4 billion of surplus. That is a huge surplus, and would have been unfathomable to the founders of many of these housing associations. Why is all this money just sitting there, after all the money is being paid? Probably some of it has come from illegitimate service charges. So they're not going to collapse if they don't get your £20 or £30 or £100 or whatever it is that you owe them. So we are supporting people to withhold payment, and that's what we would advise people to do, is to write to their landlord, copy in their MP, let them know why they're not doing it and what element they feel is illegitimate or extortionate.
Thank you so much, Suze. I have one final question for you, and then I'll ask you if there's anything else you'd like to cover. But we also put this to the other panellists. So will SHAC stakeholders, the people that you work with, will they benefit in any way from transparency measures outlined in the Leasehold and Freehold Reform Act, in your opinion?
Not unless the enforcement gap is addressed. So, if the legislation is already there, at least for leaseholders and shared owners, that should mean none of these problems exist, because the Landlord and Tenant Act already says that service charges have to be reasonable and reasonably incurred. There is already a requirement under Section 21 and Section 22 to share information with tenants and residents. The problem is that the landlords can ignore that with impunity. So you can put all the legislation, I mean not you, but government, can put all the legislation it wants in place. If it doesn't think about how that will be enforced and what meaningful sanctions can be applied with landlords who don't comply, then it's not going to make any difference. You need to have both pieces. If people can't get access to justice, and even when they do, those courts can't actually enforce anything, then it's all going to be in vain. We spoke to a housing solicitor who told us that with housing associations, half of all of his cases are going back into court where the landlord has ignored a previous instruction from the courts, because they can pay the fine. Like I say, they're wealthy enough, they can pay the fine. Until we start seeing some of the affordable housing grant, for example, actually used, linked to a sanction if landlords don't comply, if they are failing their tenants and residents on these measures, then it's not going to make any difference. And that's the only thing that is really going to count to them. Can they get the grants or can't they get the grants? Regulation itself, I used to work for the regulator. I worked for the regulator for nearly 20 years. It's a very soft form of regulation, which is really about maybe can we get the investors to worry, and then the investors will put pressure onto the landlords. That's not enough. That's not enough given what the landlords are doing.
Thank you for that response, Suze. That brings us to the end of our questions.